Hello and welcome to Taylor Wessing's UPC webinar Part 3, titled The Unitary Patent. Your hosts and presenters today are Catherine Mule in our Paris office, Matthias Hilsebig in our Düsseldorf office, and me, Nigel Stote, in London. So far in our countdown to the UPC series, we have discussed opt-out and the transitional period, as well as the place that the UPC will occupy in the wider European patent system of national courts, EPO, and Court of Justice of the European Union. We would now like to start focusing on the court itself, and of course the unitary patent, which is such a large component of the new system. It is the unitary patents that we concentrate on in this, the third webinar in our series. In particular, we will discuss the nature of the unitary patent, licensing, translation, and fees. We will also address the geographical scope of the patent in the early years of its operation. But before we start, I should like to give you a brief update on the progress of the unitary patent and the UPC since our last webinar in September. On the 18th of November, Advocate General Bott of the Court of Justice of the European Union gave his opinion that the actions against the unitary patent and its translation regime should be dismissed. Subject to any new challenges, if followed by the CJEU, this will clear the way of legal hurdles to the new patent and the new court. Meanwhile, the Preparatory Committee has published a tender for the creation of the court's IT system, and the training of the first tranche of judges is beginning. In fact, the formal recruitment process for judges is expected to start shortly, and so if anybody in the audience is considering a career in the judiciary, now is the perfect time to apply. As regards when the court will actually start, consensus is now forming. It's going to be January 2017. So with that, I shall now hand over to the first of our speakers, Matthias Hilsebig, in our Düsseldorf office.
Thank you, Nigel. The unitary patent, as you can see from our first slide, is created by the so-called Unitary Patent Regulation of the European Union, in which it is described with its full format title, A European Patent with Unitary Effect. Article 3, paragraph 1 of this regulation states that a European patent granted with the same set of claims in respect of all the participating member states shall benefit from unitary effect in the participating member states, provided that its unitary effect has been registered in the Register for Unitary Patent Protection. In other words, a unitary patent is a form of classical European patent that has been registered as having unitary effect at the European Patent Office after grant. The unitary patent has the effect of a single right conferring on its proprietor and licensees the right to prevent a third party from committing the infringing acts that are set out in the UPC agreement in all the participating member states. Please note that the protection provided across the participating member states must be uniform. Only classical European patents granted for all the participating member states and with all the same sets of claims can benefit from unitary status. This, as the Unitary Patent Regulation Recital states, ensures the fundamental purpose of the unitary patent as a patent of uniform scope of protection across Europe. This requirement does, however, raise questions about what happens about member states who have still not ratified the new system when it starts. Catherine will deal with this issue shortly. There is, however, an inherent downside to the breadth of protection provided by a unitary patent. This is that any change to the status of the patent must also take effect across all the member states as a whole in uniformity. Here lies the greatest risk to the patentee who is registered for unitary effect, and indeed also for patentees of classical European patents that are not opted out of the UPC. A successful revocation of a unitary patent in one action has effect across all the participating member states. Article 2 of the regulation makes clear about the unitary patent that it may only be limited, transferred, or revoked or lapsed in respect of all the participating member states. It also follows from Article 2 of the Unitary Patent Regulation that limitations on a unitary patent by post-grant amendment will have equal effect across the participating member states, as will lapse too. The assignment of a unitary patent must also be made for the entirety of the patent. This is in contrast to classical European patents, where the different national designations of the same patent may be assigned to different proprietors. Although a unitary patent must be transferred in its entirety, the regulation states that a unitary patent may be licensed in respect of the whole or, please note that, part of the territories of the participating member states. The implication of this provision is not only that licenses may be granted to different licensees for different participating member states, it also means that any dealings that are based on licensing, such as charging a patent, for example, will also be possible for the whole or a part of the territories of the participating member states. However, what is not at the moment abundantly clear from the part of the regulation as shown is whether such licenses can be granted for different territories within a participating member state. The best view on this is probably that this is allowed in the same way that it is for European patents. The proprietor of a unitary patent must also file a statement with the EPO saying that it is prepared to grant a license in return for appropriate consideration. The regulation also suggests in its recitals that a statement of that kind should allow a reduction in renewal fees. However, at the moment, no further details of this work or the amount of the reduction have been made available so far. It is likely that this will be dealt with at the same time as renewal fees, probably later this year. Compulsory licenses of unitary patents are also possible. The regulation says that compulsory licenses for unitary patents are to be governed by the laws of the participating member states to be covered by the license. This means that compulsory licenses must be justified on a country-by-country basis according to, please note that, national law. However, there seems to be no reason why it should not be possible to obtain such licenses in one set of proceedings in the UPC. But this remains to be clarified in the future. In any case, application of compulsory licenses along national lines is consistent with a unitary patent as a right that may be licensed in respect of the whole or part of the territories of the participating member states. There is an yet unanswered question about whether a unitary supplementary protection certificate will be created, which in effect can be granted on the basis of a unitary patent. The alternative is that the existing system of national SPCs will be adapted for unitary patents as well. Both alternatives would require amendment to the current European legislation, but the second option is the less radical, with a fewer changes required. The issue of how SPCs on unitary patents will work raises other complex issues, including the nature of the marketing authorization upon which these SPCs will be based. In particular, must they be centralized, decentralized, or perhaps national? And how is uniformity of protection to be ensured across the participating states, considering that patent offices can't take different approaches to SPCs? Furthermore, although it is the less disruptive solution, requiring patentees to apply nationally for SPC protection on the basis of a unitary patent would not be in line with the efficiencies and cost savings that unitary patents are intended to introduce. These issues, as we understand them, are currently being considered by the European Commission. Both the Unitary Patent Regulation in Article 6 and the UPC Agreement in Article 29 contain exhaustion provisions. They are drafted in similar terms and are applicable to unitary patents and classical European patents at the same time. These articles say that the protection of these patents do not extend to products covered by the patent after that product has been placed on the market in the Union by or with the consent of the patent proprietor, unless there are legitimate grounds for the patent proprietor to oppose further commercialization of the product. These provisions therefore reflect the principle of EU patent exhaustion that has been confirmed by the European Court of Justice a number of times. This doctrine applies to all EU territories protected by a classical European patent, regardless of whether the member states in which the product protected by the patent was first placed on the market is contracted to the UPC agreement, or whether it is a contracting member state that has not yet ratified. However, unitary patent protection cannot be exhausted by placing a product on the market of a member state in which no unitary patent protection exists. I will now hand back to Nigel in our London office.
Thank you, Matthias. Requesting unitary effect. There is no filing and prosecution of a unitary patent as such. Instead, the applicant for a unitary patent files and prosecutes in the European Patent Office in the normal way for a European patent, or classical patent as they may be referred to avoid confusion. However, the additional step is then made of filing a request for unitary effect with the EPO. This request must be within 3 months of the date of publication of the mention of the grant in the European Patent Bulletin. So if unitary effect is not requested for a classical European patent within this period, the opportunity to obtain unitary patent status for that patent is lost. The EPO currently states that the details of the procedure to request and validate a unitary patent are yet to be prepared. Although the request is made after grant, the unitary patent takes effect retrospectively in the participating member states on the date of publication by the EPO of the mention of the grant of the European patent. Renewal fees. The EPO will also be responsible for collecting, administering and remitting renewal fees for unitary patents and for keeping a register of unitary patents. This will include legal status information such as licenses, transfers, limitation, revocation or lapse. Renewal fees for unitary patents must be paid by the proprietor to the European Patent Office. Renewal fees are due in respect of the years following the year of publication of grant of the patent, rather than the date at which unitary effect is entered in the register. Fees are payable for late payment of the renewal fee, and failure to pay a fee will result in the lapse of the patent. In circumstances where the proprietor of a unitary patent has filed a statement with the office to say that the patent is available for licenses of right, under Article 8.1, the subsequent renewal fees for the unitary patent will be reduced. On the important subject of the level at which renewal fees will be set for a unitary patent, the EPO currently says that this is still to be prepared by the Select Committee of the Administrative Council of the EPO. We understand that further announcements on this subject are expected to be made shortly, but other sources suggest there could be delays until later in the year. Language. The Translation Regulation number 1260/2012 is a complement to the Unitary Patent Regulation. It deals with essentially 2 issues of language. The first is the language of grant of unitary patents, and the second is the language of translation in cases where a unitary patent is disputed in the UPC. The language of grant is provided for in Article 3 of the Translation Regulation by reference to the European Patent Convention. This means that the specification of a unitary patent must be published in the language of prosecution, English, French, or German, and must also include a translation of the claims in the other two official languages of the EPO. In other words, the claims must be present in all three of English, French, and German. Furthermore, a request for unitary effect must be submitted in the language of the proceedings. The translation regulation also provides for translation of a unitary patent in the event of a dispute concerning a unitary patent. There are two scenarios in which translation will be required. In the event of a dispute in which case the patent proprietor must provide a translation into the language used in the proceedings of the court if the court requests it. That's the first. The second is in cases where issues of alleged infringement are raised. In these cases, the alleged infringer can require the patent proprietor to either provide a full translation of the unitary patent into an official language of the participating member state of their domicile, or the language of the participating member state where the infringement took place. In these second cases, the choice of the alleged infringer helps to offset the potential disadvantage to the defendant of an action being brought in a local or regional division of a member state where the language of proceedings is unfamiliar. Furthermore, the translation regulation provides that in a dispute concerning a claim for damages, the court will take into consideration whether the alleged infringer acted without knowing or without reasonable grounds for knowing that he was infringing the unitary patent before having been provided with the translation. For this purpose, the provision takes particular account of the knowledge of an SME, a natural person, or a non-profit organisation, a university, or a public research organisation. However, it's unclear still whether providing a translation to the alleged infringer is intended to automatically put them on notice and satisfy this knowledge requirement. The practical point is that a proprietor should provide a translation to an alleged infringer as soon as they become aware that an infringement may be taking place or about to take place, thus protecting their position on damages. The cost of these translations will be borne by the patent proprietor. Where it's necessary to communicate the content of the patent in other languages, high-quality machine translations will be available. However, the translation regulation provides for a transitional period of currently 12 years whilst the machine translation system is set up and quality is established. And during this period, if the language of the proceedings before the EPO is French or German, a full translation of the European patent specification must be provided into English. Or if the language of the proceedings is English, a full translation into an official language of an EU member state must also be provided, and this translation must be provided by the patentee together with its request for unitary effect. So that's it on language. I shall now hand over to Catherine Mule in our Paris office.
There will be a time when life will be simple. This is once all the countries that are parties to the European Patent Convention have signed and ratified all the documents of what is called the Unitary Patent Package. It will be simple because unitary patents will be effective in all these countries. However, this is going to take several years. And the question, what happens in the meantime? The promoters of the unitary patent did not want to wait until everyone had signed everything. Also, the unitary patent court is key in the new system. Hence, the rule, which is set out on the slide, the unitary patent will come into force once the unitary patent court is ratified in 13 countries. Then the next question is, what will be the geographical scope of these new unitary patents? And the answer is in Article 18.2, which says A European patent for which unitary effect is registered shall have unitary effect only in those participating member states in which the UPC has exclusive jurisdiction with regard to unitary patents at the date of registration. So what you do to know what the geographical scope of your patent is you look at the countries which have ratified at the date when your unitary patent was registered. And these are the countries where your unitary patent will be effective. The consequence of that rule is that the unitary patents will have different geographical scopes depending on when they are granted. And this is what is illustrated on the next slide. And on this slide, each little cube represents a country. When the cube is pink, this means that the country has ratified the UPC. When the cube is blue, that's when the country has not ratified. And the cube in orange, marked PL, stands for Poland. And Poland is kind of different because Poland has signed the regulation, but it has not signed the UPC agreement. So on the top part of this slide, you see that at the beginning, that is, just once 13 countries have ratified the UPC, then all unitary patents will be effective in those 13 countries. Further down on the slide, this is a situation later on when a unitary patent is registered when, for example, 18 countries have ratified the UPC. And then all these unitary patents will be effective in those 18 pink countries. In other words, the geographical scope of the unitary patents will extend over time as more countries ratify the UPC. So far, it's pretty simple. But now I'm going to talk about problems that arise as a result of two provisions in the regulation that could be interpreted in a strange way. The first provision is Recital 26 of the regulation. This recital says here on the slide, patent applicants should remain free to obtain either a national patent, a European patent taking effect in one or more of the contracting states to the EPC, or a unitary patent validated in addition in one or more contracting member states to the EPC, which are not among the participating member states. So the problem with this wording is that we have here a list of three possibilities: national patent, European patent, unitary patent, etc. But in fact, when you think about it, there is a fourth possibility that is not in this list. The fourth possibility is a European patent, I mean a classical European patent, not a unitary patent, which is effective in countries which are not participating in the unitary patent. And because this fourth possibility is not in the list in Recital 26, people have wondered, does this mean that this possibility is not open? But the general view is that it doesn't mean that, and that applicants will still be free to file European patents for countries that are not participating. Another problem of interpretation is what is referred to as the Malta-Croatia problem. And this arises as a result of the wording of Article 3.1 of the regulation. So, Article 3.1 says that a European patent granted with the same set of claims in respect of all the participating member states shall benefit from unitary effect. The problem is that Malta and Croatia joined the European Patent Convention later than the others. They joined respectively in 2007 and 2008. The consequence is that European patents that were filed before 2007 and 2008, they are not effective in these countries. And this means that in these countries, there is no set of claims at all. So if you look back at Article 3.1, does this mean that all these old patents can never become unitary patents? The consequences of this interpretation would be huge, because it is estimated that 1/3 of the European patents being prosecuted falls within this category. However, fortunately, one way to avoid this is what is shown here in the next slide. It's to interpret Article 3.1 to mean that in order to have unitary effect, the European patent must have the same set of claims in all countries where it is effective. And this will not be Malta or Croatia. However, this may be one of the first issues which the Unitary Patent Court will have to decide upon. Thank you for your attention, and I will now give the floor back to Nigel to conclude our presentation.
Thank you, Catherine. That concludes this webinar, and it only remains for me to thank you, our listeners, for joining us here today. As you will see, the UPC is starting to take shape. And to make sure that you stay one step ahead, please look out for and join us at the next Taylor Wessing UPC webinar.